Thank you very much for staying with us. Those of you watching us on SABC2 and, of course, on our SABC News channel on DSTV. Well, a liquidation application brought by Eskom against Trillian Management Consulting has been heard in the Gauteng High Court in Pretoria. The Gupta-linked company reportedly owes the power utility nearly 600 million rand. Meanwhile, the South African Revenue Service has refused to confirm or deny that it has attached assets belonging to Trilian and its sole director, Eric Wood. Reports say in January, Eskom applied for a liquidation order against Wood and Trillian. It further applied for a contempt of court order against Wood for his failure to pay back almost 600 million rand owed to Eskom. A global consulting firm, McKinsey, appointed Trillian to assist with a turnaround strategy for the embattled utility. But it later emerged that Trillian did not have a valid contract and had overcharged Eskom. For some clarity on the matter, we're now joined via Skype by accountant and commentator Kaya Satola. Very good morning to you, Kaya. Thank you so very much for joining us here on Morning Live.
Good morning and good morning to the viewers.
Just as a start, Kaya, I suppose for us to understand where we are now, we should perhaps look back a little bit. So, of course, Trillian was actually subcontracted by McKinsey, who were the actual contract holders with Eskom. But last year, McKinsey actually sort of settled with Eskom in 2018, agreeing to pay back nearly 1 billion rand and admitting that they'd overcharged the parastatal. One would think that the matter would have already been settled with McKinsey last year, so that we're not here again with Trillian, seeing that the contract was indeed with McKinsey. Tell us what's going on right now.
Well, again, as you correctly say, the primary contract was between Eskom and McKinsey, and what Trillian was that it was a subcontractor. So naturally, if McKinsey is now saying that they are paying back the money, which they've already done, over 1 billion rand, they are themselves acknowledging that the contract was either tainted or value for money was not delivered to Eskom. So it is therefore quite ridiculous to imagine that Trillian can still insist that it delivered value for money and it is entitled to the 595 million rand. So that's been the point of dispute since 2018. From the time McKinsey paid it back, you'd have thought that by default or by consequence, Trillian itself would have acknowledged that, well, if the people who brought us in, if the people on whom we rely to actually receive a single cent out of this contract are now saying that the contract is so fundamentally flawed, they must pay back the 1 billion rand. We do not have any leg to stand on to even allege that we're entitled to the money. So that would be the common sense application of it. Unfortunately, though, of course, Trillian has decided to take the view that they believe that they delivered value to Eskom and therefore they're entitled to the money, which is why they still haven't paid the money. And Eskom has had to go through extraordinary means to try and recover this 595 million rand plus interest that's due to them.
Yeah. I mean, what is the likelihood then that, Eskom will indeed be able to recoup that 600 million rand that is owed to it? I mean, I'm just reading at some of the comments made by Eric Wood, the sole director of Trillian, and he's saying, well, look, in any case, he's maintaining the fact that, look, we're broke. We don't have that money in any case. But, we've also seen reports of, his lavish lifestyle over the years. How likely will they be able to sort of get something out of this?
The likelihood is very low. And I think the reality now is that Trillian in its current form is essentially a shell company. Yeah. Now, how it became a shell company, of course, is something that we'll never know because no one can dispute that an amount was received up to 600 million rand. And where that money went is now the mystery that only Eric can solve. So if he legitimately says that, look, there's no money left, it really becomes a difficult situation for Eskom to say, well, let us go to the court and try to pursue this, because the courts may indeed judge in Eskom's favor, which is what they did in October last year, only for Trillian to say, okay, that's good, you really are entitled to the 600 million rand, but it quite simply doesn't exist. And even last year, Eskom tried a different approach, which was to say that if Trillian insists on challenging this matter in court, we want them to exhibit that the money exists in the first place, rather than us engaging in all this expensive litigation, eventually winning it, only for them to say, congratulations, but there's nothing left here for you to attach. Yeah. So I do believe that the likelihood of anything being recovered is quite simply non-existent at this stage. And the more we delay, without any of these assets being frozen, or at least Eskom being able to ensure that the assets are not moved, if any assets still exist at all, you'll go through the litigation process, and when you're done, they'll simply tell you there's no money left, and then there'll be nothing to recover anyway.
Well, as you say, Trillian is commercially insolvent and, in fact, ceased trading in 2016 after it was allegedly linked that they were related to the Guptas in some way. Is Eric Wood then correct, or does he have a point rather in saying that, Eskom's efforts are somewhat are somewhat frivolous and vexatious? I know the term, frivolous and vexatious is often used by legal practitioners, but does he make a valid point there? The fact that there's really no point. I mean, Eskom has also tried to sort of say, well, look, if we're not going to get money out of this, then somebody needs to go to jail. So what's then going to be the step going forward?
I think the context of the terms frivolous and vexatious are usually used when somebody says you are pursuing me without just cause. So it's usually somebody who says, look, you are launching this action, but you actually do not have a legal standing, or for some other reason you're doing it maliciously. So that's usually the context of people saying that this attempt is frivolous and vexatious. In this particular instance, Eric Wood would find it difficult to argue that Eskom's actions are not warranted because, again, he was, the additional person in a contract that has already been dealt with in a particular way. So that's the starting point. Now, obviously, the issue here relating to Eric Wood is that if he says that there are no assets left, we then have to go and look at the legal framework that says, well, if somebody comes and takes something from me, and could be in the form of money or any other asset, and then through the litigation process, it tells me that he's either destroyed that asset or that asset no longer exists, is at the end of the road for me. What other recourse do I have? So in this context, what Eskom has simply said so far is that as far back as October 2019, the High Court said that, yes, Trilian must pay back the money, and Trilian simply hasn't paid back. So what they've said so far is that by failing to make the payment, for Eric Wood and by Trilian, which is now the same thing, is in contempt of court. So therefore, they've asked for the court to slap him with a fine of either R1 million or jail him for 30 days. They haven't got to the stage yet of saying, well, now that we realize that the money is there or isn't there, what other recourse do we have? What other recourse do we find if the money itself is not available to pay back? So we're going to have to wait until this particular hearing is finished to see what other recourse Eskom is seeking, if, of course, Eric Wood can legitimately indicate that there is no money left.
I mean, it does seem that Eric Wood doesn't really have much of an interest in actually paying back Eskom, even if he weren't insolvent, even if Trilian wasn't indeed insolvent. Do you think there are other reasons why Trilian, in fact, resisted paying back Eskom, even if they were not insolvent?
Look, I think the problem with entities like Trilian is that what you do with one particular transaction sets a precedent for other transactions. So, of course, this wasn't the only transaction that Trilian would have been involved in. This wasn't the only management consulting engagement they would have had at that point in time. So perhaps the fear is that if we yield on the Eskom matter, somebody else who now looks at what we did and sort of identifies similar traits in that contract will now say that on the basis of how you've conceded on the Eskom matter, we're also going to put forward the same sort of demand and ask you to pay back the money. So there's always that reality that once you do a particular course of action, you are then stuck with the precedent, and then it becomes difficult for you to extract yourself from that, unless, of course, that particular secondary case is so fundamentally different from the Eskom case that those people could not rely on Eskom as a precedent. So that's the one part of it. And then I suppose the secondary matter is the question of why Trilian was set up and whether it really was a bona fide management consulting company that sought to deliver value to entities like Eskom. And for a lot of people, it now appears that it really was just a money laundering conduit, which was to say, go in there into the state-owned enterprises, attach yourself to this blue brand company like McKinsey, for example, or KPMG, for example, extract some other supplier development fee, and then do what you want to do with that money. So it's quite possible that nothing ever stayed in the Trilian accounts long enough for anyone to actually say, well, this is what existed, this is what we should find. The problem, of course, with Trilian is that it is very difficult to even know what exactly was going on, why was it set it up, and what exists within the company in the state.
Yeah, I mean, let's talk about, state capture. And, Kaya, we've heard about Trilian's involvement in many things at the state capture inquiry. And, my question to you is, if there are, what exactly is the point then of the commission if there aren't any consequences? I mean, when you look at, Eric Wood, he seems to not be very worried about the fact that, his company was named in the state capture and, allegations, of course, that there were links to Salim Issa, who's, an associate to the Gupta brothers. What exactly, can happen. And it seems that, out of the state capture inquiry, it's almost like it's consequenceless. And then, so one needs to then ask, well, what is the point? Why are we sitting here naming all these companies who might have been involved in state capture, who have some been even proved to have been involved in state capture, but it seems that there aren't really any consequences then?
I think it is the great tragedy of how our law enforcement agencies and our political systems tend to work in parallel. And for a lot of people, as soon as you say that you're initiating a commission, particularly a commission of inquiry, it then gives them the impression that it means that all the other law enforcement processes are suspended, which is not actually the case. So we are still not in a position to understand why, if people are already able to see all the evidence, well, if we want to call it evidence that's been brought towards at the Zondo Commission, why none of the other law enforcement agencies have at least initiated some action to say, let us act on this, let us bring these people into the room and ask them, from what we've heard, whether there's any evidence to back it up. And I think the problem with the Zondo Commission is that the Zondo Commission is not a traditional law enforcement process. The Zondo Commission seeks to be more collaborative. It seeks to give everyone the right of reply. And unfortunately, that is taking forever. The reality here is that Zondo has asked for yet another extension. But if we had to stop the Zondo Commission today, absolutely nothing that has been heard would lead to any consequence, because quite simply, you've heard one version of the story, you haven't been able to cross-examine people, and you haven't really been able to objectively test the evidence. So it's taking far too long to even get the simple matter sorted. Yeah. And I think the great tragedy of the Zondo Commission is that it hasn't itself narrowed itself down to saying, let us deal with matter one, whether it's Transnet or Eskom, go through all the testimonials, go through all the cross-examination and say that matter is finalized. They've simply opened up multiple avenues of evidence, multiple avenues of different matters that are being tested. And at that point in time, it's really a combination of far too many things happening at the same time. Yeah. And the effect and the consequences that absolutely nothing of substance can then be taken forward. And I think the problem that we're going to have to deal with is, if we had to stop this commission, because at some point in time, we're going to have to do so. Yeah. What exactly can we do with the information that has been gathered? And unfortunately, the answer, as we sit on the 6th of February 2020, is that absolutely nothing that's been tabled at the Zondo Commission can really get us very far in the terms of pulling people to account and actually having some consequence management there. You would imagine that if this commission was set up on the basis of the Gupta family, perhaps at some point in time of the past 2 years, they would have taken a stand. People that were intrinsically involved in really shifting the money for them would have taken a stand. And here we are, none of it has happened yet.
All right, Kai, just as we close off our conversation, I just want to end off with a rather practical sort of question. And one doesn't want to suggest that Eskom should let it go, should let go of, all these companies that have taken money from it. But, what is the cost really to Eskom in terms of legal costs, chasing after all these people? At the end of the day, they are losing more money and, in fact, trying to get money, which might not, in fact, happen. Would it be wiser for Eskom to, perhaps say, listen, let's just cut our losses at the end of the day?
Look, it would be much better if our law enforcement agencies were strong enough for me as Eskom to say, look, guys, this is what happened in our entity. Here's the evidence. Please go and follow it up. Because then that doesn't mean that I have to incur the cost of pursuing these people. Unfortunately, being as fragmented and perhaps not as skilled as they ought to be, our law enforcement agencies aren't even in a position to step in to say, okay, Eskom, thank you for this information, we'll take it going forward. And if we're at least in that position, then you'll be able to say that companies that have been done wrong do not get doubly prejudiced. And unfortunately, in this case, you do suffer double prejudice in that you're saying that people took money from you, and now you have to spend even more money trying to get them to admit that they took it, and then even more money to try to force them to pay it back, which is what we're seeing now in the Trillian case.
Yeah. Kaya, always a great pleasure speaking to you. Thank you so very much for giving us your time here on SABC News on Morning Live. Thank you, sir. That's Kaya Setola, accountant and commentator. Let's take a look then at your leading